Good morning and welcome everyone. Thank you very much for joining us for the fifth webinar in our CLE series, Key Legal Considerations for Business Reopening and Rebounding. Today's program will focus on restructuring strategies in light of COVID-19. My name is Monique DeSabatino. I'm a partner in Saul Ewing's bankruptcy and restructuring practice based in Wilmington, Delaware. My practice is focused on a broad range of commercial bankruptcy matters, workout matters and restructuring matters in which I've represented a variety of parties, particularly Chapter 11 debtors, borrowers, and trade creditors. I'm very pleased to introduce you to my partners who are the presenters for today's webinar. We have Jeffrey Hampton and Mark Minuti. Jeffrey serves as chair and Mark serves as vice chair of the Bankruptcy and Restructuring practice. Before we begin, there are just a few housekeeping announcements. First, for Q&A. Questions can be submitted through the Q&A tool at the bottom of your screen, or if you're on an iPad, it's likely on the top of your screen. While we will do our best to answer all questions submitted during the webinar, if we do run out of time, we will follow up individually by email as soon as possible after the presentation. Second, with respect to CLE, today's program has been approved for distance learning CLE credit in Pennsylvania, New Jersey, and Delaware, with applications pending in Minnesota and Florida. As a CLE provider, we must be able to verify your attendance. We will not have slides on the screen during the presentation today, but at 2 random points during this webinar, I will announce numeric recording codes. You should record these and report them back to us using the CLE survey that you received in your webinar reminder email earlier today. We will in turn send you your certificate of attendance once we receive your survey response. Please be sure to respond to the Saul Ewing Arnstein & Lear CLE survey with your numeric codes within 5 days of this program. Next, within 48 hours after this program, you will receive a thank you for participating email. This email will include the links to today's webinar recording, as well as any handouts and the CLE survey. And finally, I suppose no legal presentation is complete without a disclaimer, so here's ours. The provision and receipt of the information in this presentation is not legal advice, does not create a lawyer-client relationship, and should not be acted on without seeking professional counsel who have been informed of the specific facts. So there you go, and with that, we'll begin, and I will provide our first CLE code, which is 032593. Again, it is 032593. Take it away, Jeffrey.
Monique, thank you for that comprehensive introduction. Appreciate it.
No
and
problem.
Good morning. Good morning, everyone. And thank you for joining us this morning. We look forward to spending the next hour with you to talk about restructuring issues relating to sort of our emergence, hopefully, from the coronavirus environment. My name is, as Monique mentioned, Jeffrey Hampton, and I do chair the bankruptcy and restructuring practice at Saul Ewing. I have been with Saul Ewing now for 30 years. My practice, and I'm based in the Philadelphia office, and my practice is primarily representing debtors in both in-court and out-of-court workouts, all sorts of parties in restructuring, whether it be in a forbearance arrangement, loan workout, refinancing, out-of-court remedies, purchase and sale of assets through bankruptcies. And I'd like to turn it over to my colleague, Mark Minuti, for him to introduce himself, and then we can get started.
Good morning, everybody. I'm Mark Minuti. I'm one of the co-chairs or vice chairs of the Bankruptcy and Restructuring Department here at Saul Ewing. I'm based in the Wilmington, Delaware office. Like Jeffrey, I've been here for approximately 30 years, my entire career. After a 1-year clerkship in Delaware. My practice, very much like Monique and Jeffrey's, a full range of restructuring representations, including debtors, committees, creditors, landlords, as well as representing parties in sophisticated bankruptcy litigation. Overall, the firm has, in addition to Jeffrey, Monique, and myself, we have 14 other full-time restructuring lawyers spread over 6 offices. And again, full service representing almost every constituent in a bankruptcy case, other than we typically don't represent secured lenders in these cases. So let me turn it over to Jeffrey, and he'll describe a little bit of specifics in terms of what we do.
Thanks, Mark. So in terms of our representations and the work that we do, if I were to summarize it in one sentence, it would be we represent troubled companies of all varieties, whether it be in a out-of-court restructuring, whether it be in a loan workout, perhaps there's a loan default, a covenant default. Oftentimes a borrower is in a situation where a lender has decided it no longer wants to be in a particular industry or space, so we will work with that borrower and negotiate a loan restructuring, perhaps a forbearance agreement to hold off on the lender's exercise of remedies to allow time for either a sale process or a refinancing. We do represent companies in bankruptcy as well, Chapter 11 debtors. We do quite a bit of that work. We also, in the bankruptcy context, represent unsecured creditors committees in Chapter 11 proceedings. And we do represent a large number of what I'll describe as sophisticated unsecured creditors, trade creditors, other parties in bankruptcy. We also represent landlords, and we represent independent board members who are often brought in a distressed environment to help provide independent advice to a company. We represent contract parties. So for instance, we help our clients deal with vendors that may be in financial distress, managing that relationship, or customers that may be in financial distress. Also to deal with, on the landlord side, with some tenants that could find themselves in financial trouble or in bankruptcy. We do not typically represent what I would call money-centered banks. That is something we shy away from a conflict perspective. Our most visible work is in the Chapter 11 arena, right? In a bankruptcy case is a public filing. It's a very public proceeding. For instance, most recently, myself, Mark, and Monique have been representing for the past year in the Philadelphia area, but in a case pending in Wilmington, Delaware, both Hahnemann University Hospital and St. Christopher's Hospital for Children, along with 12 related companies in bankruptcies. So that's a perfect example of a very high-profile bankruptcy proceeding. But a lot of the work that we do and that others in their structuring space do is actually outside of court. And you really wouldn't know about it unless you were directly involved. So for instance, at the same time we were representing Hahnemann and St. Christopher's, we were working on a complex restructuring and sale of a healthcare business in Pennsylvania, again, an out-of-court proceeding. We were also negotiating a forbearance agreement with a large food manufacturer and distributor. We were involved in an out-of-court workout for a national company in the security business, and also doing an out-of-court workout for a mid-sized retailer. So that sort of gives you the sort of the sense of the depth and breadth of the practice areas that we participate in. Mark, do you want to talk a little bit about the webinar?
Certainly, Jeffrey. So obviously COVID-19 has caused unprecedented business disruption across all sectors, and a significant number of businesses have faced unprecedented disruptions in supply chain, trouble with their own vendors and customers, manufacturing interruptions and the like. There's also, obviously, businesses are also dealing with constrained credit markets, which have led to liquidity challenges, again, across all sectors. What we're going to talk about in the seminar today really is some things that we think you or your clients should be doing to deal with those issues as the economy starts to open. A theme you're going to hear throughout today that Jeffrey and I will beat the drum on is the idea that you really need to be diligent and really understand your business and have a firm grasp on really what is your business going to look like going forward, again, as we come out of, or as the economy starts to open up, as states start to open up and we move forward. Another main theme you're going to hear as we go forward today is, not only understanding your business, but to the extent you see you have a problem, be proactive with respect to that problem. So if you've got an issue with your lender, our advice really is, and our guidance is, be candid, be upfront, and be proactive because you're going to need some help getting through these troubled times. And that's the way I think you're going to maximize your ability to get there. So in terms of specifics, Jeffrey, why don't you talk about some of the things we're going to be talking about today?
Yeah, I think what we want to try to touch on is options that you may have if you're dealing with a troubled company or perhaps a company that's in sort of a troubled space, a troubled industry, whether it be a supplier, whether it be a customer that you have, whether it be a tenant or a contract party. We want to try to give you a little bit of guidance of how to try to address some of those issues, options that you may have, and what to think about and look for to identify some of those parties. Because with the environment that we've been in over the past several months, it's unprecedented, as we all are aware, and it's going to take a little bit of due diligence on your part as well to try to examine the relationship that you have with others that you're doing business with. In addition, we want to chat with you a little bit about what you should be thinking about if your company, your business, whatever it may be, is facing financial challenges or even in financial distress. And also if you're really in an industry that might in fact be aligned with other businesses that are in sort of financial distress. So for instance, in the automotive industry, what we're seeing, and we'll talk more about this later, but what we're seeing is at the supplier level, there is a good bit of distress. So for others that participate in sort of that whole tier of distribution, what might that mean and what options do you have to try to help you through that? In terms of what we're seeing in the market currently, Mark, you want to sort of talk everybody through of what we're seeing right now?
Sure. I mean, look, obviously everybody knows this is unprecedented times. And the last sort of big wave in terms of restructurings we saw was back in 2007, 2008. But based on what we're hearing and what we're seeing, this is going to be bigger. And again, like nothing we've really seen in our careers. While certainly some businesses, reacted maybe better than others in light of what happened, and others are better able perhaps to weather the storm, very few really saw this coming or appreciated the depth of the disruption that we'd all experienced as a result of COVID-19 and what it's meant. One of the things that I would stress is we remain very much in an unknown, fragile environment when it comes to financial issues. Nobody really knows when it's going to be over. When are we going to be back to normal? What is the new normal going to look like? We're involved in the Hertz bankruptcy case. It's a huge bankruptcy case, and I attended the first day hearing. And I thought the debtor's lawyer there did a pretty good job of painting a picture about how dramatic this was, where literally overnight the business turned on a dime, and they literally spent the entire month before the filing putting out fires and trying to figure out, how they could preserve their assets to best position themselves to go into bankruptcy. And one of the things they said at the first day hearing really resonated with me, which is that, all of their previous business prediction tools, so they could come up with budgets or come up with a business plan or map things out, all those are out the window because nobody really knows when it's going to come back and what it's going to look like. And I think that's really across the board for all businesses. Now, so far, in terms of what we've seen publicly, you've seen a lot of large companies file for bankruptcy. And Jeffrey, why don't you give a few of those examples?
Yeah, so it is interesting in terms of what we've seen recently, and I think everybody probably participating in the webinar has heard about some of these filings, or many of them, because they've been very public. So Mark mentioned the Hertz bankruptcy filing, which obviously has been very high profile. There's also been a lot of retailers, larger retailers that have filed for bankruptcy. Pier 1, Neiman Marcus, J. Crew, J.C. Penney, and then sort of related, Gold's Gym filed for bankruptcy, another large gym up in New York. Stage Stores, True Religion, a large LASIK Vision Centers, which is a large LASIK provider in the United States. And most recently, late last night or early this morning, GNC, General Nutrition Centers, filed for bankruptcy. Also seeing a lot of filings in the oil and gas space, obviously with the collapse in oil prices over the past several months, with a decrease in a need in demand and yet increased supply, the market has been creating some challenges. Also seeing activity in the hospitality space, primarily with restaurants, larger restaurant chains, which actually have the ability to file for Chapter 11. Unlike some of their smaller, a lot of the smaller restaurants may not even get to have the ability to try to get that protection. And then in terms of what we, see generally, retail already very active. We think it's going to become more active. We also think healthcare is going to become even more active, particularly on the provider side, be it hospital or practice groups. Also food distribution and agri businesses, logistics companies, and as I mentioned a few minutes ago, auto parts suppliers and others in that distribution. Before we, it's funny that, wasn't too long ago when we were sort of in what we call the pre-pandemic environment earlier this year. And at that point, there was a lot of really reasonably priced money in the marketplace. So you had lenders, a bank, a traditional bank, competing with non-bank lenders, whether it be a private equity firm, a hedge fund. So there were a lot of opportunities and a lot of capital to deploy. So even companies that were perhaps a little financially distressed were able to stay afloat with so many funding options available. It was a matter of pricing and terms and other things, but they could stay alive. You really had lenders at that point dealing with not as many defaults as a result, or a little bit more of what we refer to as the kick the can down the road mentality, which is, well, maybe we have an issue today, but perhaps in another year or so, if we provide a little more flexibility, those problems will go away. Lenders were very receptive to workouts and forbearance arrangements. Today, just now recently, the environment is very different. I think one thing that's helped at least bridge the gap a little bit in the short term is different government funding programs, whether it be the PPP program or some other related programs that did provide some stopgap relief. I think those of you that participated in any of those programs know that there was a lot of confusion along the way with those programs, resulting in some borrowers that in fact were eligible returning those funds, which may have caused some problems, and others not really even being able to participate. But lenders right now, from what we are seeing, is they're a little overwhelmed by no surprise. I mean, pretty much just about any industry that they look at, other than an industry that perhaps is strengthened as a result of the pandemic, is in a little bit of trouble. The lenders are trying to sort of predict the market, pick the winners and losers, and really to decide where to best deploy the capital that they've got available and where to pull it back. So perfect example of that is that we were representing prior to March. We had been representing for a few months a large provider in the security business, and with a lender, a very large, well-known bank as a lender, and we were starting down a path of an out-of-court workout sale process, maybe leading to a bankruptcy filing. Since the coronavirus hit and everything sort of changed in the marketplace, we are seeing a lender that is somewhat paralyzed. We are seeing a lender that is facing, whichever way that it looks at it, a significant loss. Yet, as we speak to lenders, lenders counsel, what we're hearing is that the lender itself is struggling to decide which loans to walk away from, which loans to try to stick it out with, but on a far more accelerated basis. So in a period of about 3 months, we have probably toggled 6 to 7 different times as to the approach that we're taking based on uncertainty on the lender's part. We're also seeing that with cases that we were handling prior to the sort of the pandemic hitting, in terms of they've taken a different path, or sort of facing a little bit of a paralysis. Mark, you want to talk a little bit about kind of what the cases look like that are filing, what the goals of some of those cases are?
Sure. As Jeffrey mentioned, you have a number of different large companies we've all seen in the news that have filed, and each are taking a different tack. A lot of the cases that have filed are really cases that are about a balance sheet restructuring. So these are cases that have filed where there's a pre-negotiated or pre-arranged deal with the lenders, whereby, maybe there's going to be a debt for equity swap and the company's going to come out of bankruptcy. Based on the press releases from last night, that's apparently what GNC's plan is. They're going to do a debt to equity swap and hopefully come out of bankruptcy very quickly. But, that doesn't mean there's not going to be an impact. I mean, they have made it very clear at the outset of their case that they are going to get out of 800 to 1,200 stores. So just think about the ripple effect on landlords, on lenders, and so on, that in and of itself is going to have in those cases. Something else we're seeing, a lot of cases obviously are filing as quick sale cases. That's not new. Even before the pandemic, the bankruptcy practice these days largely has switched to a bankruptcy sale process. That's the profile of most cases that file these days, which is the company goes in, it's going to sell its assets pretty quickly, and then the bankruptcy case really is dealing with the aftermath, reconciling claims and dealing with the sale proceeds. But something I think we're going to see more and more of, and we already have seen in the cases that have filed, are free fall bankruptcies. As Jeffrey said at the top of the program, we do a fair amount of debtor work ourselves, and you always want to go into the case with a plan in terms of what you're going to do with bankruptcy. As Jeffrey said, bankruptcy is a tool. So what's the bankruptcy going to be all about? And when I say plan, I don't mean a plan of reorganization, but what I'm talking about is a general idea of what you want to try to accomplish in the bankruptcy case. But in light of the sudden impact of COVID-19, you're going to see a lot of companies file that really don't have a plan, a business plan put together, or really a well thought out strategy in terms of how they're going to get out of bankruptcy. And Hertz is a perfect example of that. And they made that crystal clear at the outset of the filing. You heard a lot at the first day hearing about what happened to them and why they had to file and the issues they have with their business, but very little discussion about how it's going to come out and how it's going to get there. One of the other things, and this is really just an aside I wanted to mention, we talked about unprecedented times, and Hertz, again, is a good example of that. Many of you on this webinar probably saw that Hertz actually filed a motion to allow itself to issue additional stock, because what was happening in that case was their stock was trading in the marketplace at a pretty good number, and Hertz saw that as an opportunity to issue stock, and instead of getting a loan that obviously would have to be supported by collateral, they wanted to issue additional stock as a way to raise capital. That's the first time I've ever seen that in my career, and quite frankly, if you attended the first day hearing in the case, there's no way you would have left that hearing thinking that equity was in the money, or at least not thinking that there was significant risk that the equity was going to be wiped out in the case. Now, ultimately, I think the SEC stopped Hertz, or at least asked Hertz to delay issuing more stock, and they've stopped that now. But again, that's just an example of the unprecedented times that we're in. So Jeffrey, why don't you talk a little bit about the middle market?
So if we could just interject with a quick question, because it kind of goes to what Jeffrey was talking about before about how lenders are reacting in the market, and any thoughts that you have about how guarantors may be impacted if a bank decides that it no longer wants a relationship with a borrower under these circumstances, even though that borrower may be meeting its loan covenants?
Mark, do you want to take that?
Well, look, if the borrower is meeting its loan covenants and there's not really an opportunity or a reason for the lender to pull the loan or call the loan, in that situation, I think the lender doesn't have anything to work about. I think what's more likely to happen is you've got a borrower that is going to trip a covenant, and the bank is within its rights in that circumstance to not waive that covenant, and taking it to probably the worst conclusion is to accelerate, call a default, accelerate that loan, and then say to a guarantor, I'm sorry, you're on the hook. So in terms of what defenses a guarantor may have, or what it could argue, or what strategies there may be, and in large part is going to depend on the language of the guarantee, the language of the loan documents. But you would at least hope that there would be some restructuring strategies that can be utilized either in court or out of court to delay, a foreclosure, to delay action against the guarantor in a way that, maybe the company can right the ship and figure out how to restructure in a way that the guarantor is not going to be put on the hook for any liability that the main borrower would ultimately have. Jeffrey,
and I think you're going to see an increased amount of pressure on some guarantors where banks are going to be looking at their credit facilities and really thinking about, well, okay, maybe they'll call it, maybe they won't, but they'll use that as an opportunity to try to strengthen their position vis-a-vis the guarantors. And that's always a very difficult decision, particularly sort of in a closely held business environment. Do you improve the lender's position vis-a-vis the guarantor, such as offering collateral and otherwise? And typically what we would say in that situation is most likely no, because the reality is if the lender is looking at that loan at that point in time, it will likely, after improving its collateral position on that guarantee, still take steps relative to the loan. So it's really something you have to sort of assess the situation and really the risk and what other financing alternatives are available. So I do, one of the things that is interesting that we have talked about is a lot of the cases that we've mentioned are really sort of big name companies, right? Things you would recognize. But what's not happening yet in great number are middle market filings. So far, not as many middle market bankruptcy filings, and that's not really surprising because some of those companies are the ones that a lender or a sort of an equity sponsor is going to sort of take a little bit of time to sort of assess what options may be available with those. But we do think this is really a matter of timing. There are certainly an increased level of discussions and negotiations with lenders right now that we're very familiar with on a number of fronts and matters that we're involved with. But we work while we're attorneys and we certainly represent on the legal side, in the restructuring world, a lot of the things that we do, it's based on relationships that we have with others in the sort of the industry. So those would be financial advisors, investment bankers. And what we are hearing from them is that they are busier right now at levels than that, many people can ever remember being. There is a real sort of bustle in the market right now for a lot of the larger financial restructuring firms to beef up their ranks, a lot of the law firms to sort of beef up their ranks in the restructuring space. The involvement of lawyers is often sort of a trailing indicator because a company will first try to get some financial help, will start talking with the lender, and then only then will usually bring counsel in. I think that there is not a question in sort of our mind from not only from what we're seeing, but from the experience we've had in sort of prior market downturns, that there will be an unprecedented wave of restructurings coming in the middle market space. And it's something that if you're sort of on the side of a company that's facing that situation, the best advice we can give to someone is to try to really face the situation head on. What a lot of folks do is they'll tend to wait a little too long when there may in fact in early stage be some options available. And if you wait too long to get to the point to try to bring advisors in, at that point it may either be too late or may just be that much more difficult. Mark, do you want to talk a little bit about what companies should be doing now that the world seems to be reopening in fits and starts?
Sure, and this is really the meat of what we're going to talk about today, and we'll move through. Obviously, an hour is a limited amount of time. This seminar could be a whole day, so we'll move through this quickly, but certainly available to answer any questions either during this webinar, or certainly don't be afraid to reach out to Jeffrey, Monique, or myself at any time if you have any questions or you want to follow up on any of this. So what should companies be doing now as states and businesses are starting to reopen and lenders are starting to come out of paralysis? Well, first and foremost, we believe you should be revisiting your credit agreement and key contractual relationships so you can be proactive with your lenders, as I touched on at the outset of this webinar. Review your creditor facilities, refresh your understanding of the financial covenant requirements that may be an issue or subject to potential default in light of resettling, resulting business interruption and challenges. And if you see you have any issue that's presenting a concern, again, our advice would be to be proactive with your lender, be credible with your lender, explain the situation in a credible way, and hopefully work with your lender in an effort to reach an understanding as to a waiver of the covenant requirement a modification or a forbearance agreement to clarify that the lender is not going to exercise remedies. Again, we are encouraging folks to be candid and proactive with their lenders. Again, unprecedented time. The lenders are overwhelmed. To put it bluntly, they are going to be trying to figure out where to put their resources, which credits are they really going to focus on rehabilitating. And you, if you're in trouble, you want to be in the group of people that they want to work with, and they want to help rehabilitate the loan. So one of the ways you can help yourself be in a position to do that is really to first, on your own, credibly assess the situation, come up hopefully with a business plan for righting the ship that's credible, and then sharing that with the lender in a way where you can demonstrate that you, A, understand your business, B, you're being realistic, and C, you're taking steps to do that. And look, and when I talk about credibility, I'm always reminded of a situation that we had years ago where we were representing a borrower, and the borrower was trying to come up with this credible business plan, and that obviously involved reducing expenses, cutting costs, and so they went on their own to do that, and we kind of met with them and said, okay, let's talk about your plan, and they were very proud and presented this plan of all these costs. And then we got to the line item where, they wanted to keep their 2 airplanes. That was very important to them. That's an example where, the lender's going to look at that 2 airplanes and say, look, do you really need that? Can I really believe the rest of this plan? So that's one example. I can give you many, but the point is for the plan to be credible so your lenders want to work with you. And again, the idea is to position yourself the best way possible so that the lender believes you and wants to work with you. Jeffrey?
Yeah, and I would touch on that as well and sort of raise one other thought, and that is when you think of your relationship with a lender, funding source, whatever it may be, you have to think of that person, the relationship, who it is you're dealing with day to day at the lender, who may very well be there and willing to go to bat for you if there's a problem. But if you wait too long or sort of try to sort of massage the issue in a manner that you put that position in a very difficult situation where he or she has to go back either to their boss or to the credit committee and sort of say, oh, geez, here's the situation. And if they don't get money by next week, they can't make payroll. What you do is you've put potentially your best advocate in a position of defense relative to their job and their situation. So it is important to have that dialogue. It is important to be, it sounds sort of counterintuitive, but candid is an understatement. It's really, the idea is to try to take the approach that you're a partner together trying to resolve the problem. It doesn't mean you'll agree all the time. It doesn't mean that there's not going to be some negotiation, a little bit of yelling and screaming along the way, but it's still the best way to get there. I think part of that process of sort of assessing your situation, looking at your loan covenants and other things, the other thing that every business should be, whatever it is, whether it be in the for-profit, not-for-profit sector, large, small, obviously the world is very different now. It's been very different over the past few months. No one is able to truly predict over the next near term of several months, let alone the next year, of what it's really going to look like and what will the recovery be? What will the setbacks be? So the point of all that is it's very important to take a look at your cash flow projections on a regular basis. And by regular, that may be warranted month to month or every few weeks, depending on what you're seeing. And it's also just as important to look at your business plan. And again, I would say you have to really, really be honest and realistic to when you're looking at those and when you're revising those, and see what they're telling you, see what may be opportunities that you identify that you may be able to change from an expenditure scenario, but also just as importantly, what is your revenue going to look like? And even if you don't necessarily have expenses that you think, well, gosh, if I cut this, it'll make a difference. If you're facing a 20% reduction in revenue, you'll have to find some way to deal with that on the expense side. So it's important to do that in real time. It's important to do that on a regular basis. If you have a board, it's important to communicate with your board on a regular basis to keep your board apprised of that situation and recommendations for the strategy forward. And then I think same issue in terms of communications with the lender. If you're sitting down, you've recast your cash flow projections for the next 3 months, 12 months, whatever it may be, and you have, for lack of a better description, an aha moment that I have a problem, then start that line of communication. But in that instance, don't just go to your lender and say, oh my gosh, look at my cash flows, they don't work. You go and you say, look at my cash flow, they don't work, but here's how I think I can make them work. Even if that means you need an over advance from your lender, even if it means you need relief from a covenant, collateral to be freed up, whatever it is, but have a plan. It is very, very important to have that plan, to work with your advisors to get that plan together. And I see Monique is back.
I'm back. And so any thoughts in terms of planning on business interruption insurance? We've had a comment from one of our viewers that it may not be triggered by a pandemic event, but it may be something that businesses want to consider to see whether it's available going forward.
So I am not an insurance lawyer. I can tell you that there has been, as I'm sure most people on this webinar are aware of, there's been a lot of dialogue about whether insurance may cover some or all aspects of from the pandemic. I don't know the answer to that, and I think there's some states that are starting to legislate around that, trying to work through that, but I don't know that there's an answer. In terms of business interruption going forward, I think it's really going to be an aspect of whether that all would still relate back to the original event, that being the pandemic, as to whether that would be a way. Now, whether there'll be new insurance products that are ultimately available or enhanced insurance products, I don't know, but certainly as part of your restructuring thoughts, you should be looking at those types of things. You should be looking at your insurance coverage. You should be looking at your backup plans. And things like that. Mark, any thoughts that you have on that?
Oh, no, I think you covered it. Look, I think, I've talked to the folks in our insurance group here at the firm, and when you talk to them, they describe, unprecedented times for what they're doing as well. You've got all sorts of issues, right? Coverage issues, reinsurance issues, regulatory issues. You've got states enacting legislation that impacts insurance companies, and so I think it's going to be a while before all that shakes out in terms of what does this really mean to the insurance products that are out there now and the products that may be out there in the future.
Agreed. Mark, do you want to touch on sort of implications of customer financial challenges for folks that are dealing with troubled customers?
Certainly, in addition to looking at your own business plan and trying to come up with a credible business plan in light of these, unprecedented times, you have to obviously consider the impact of financial distress on your vendors and your customers as well as you move forward. I mean, as much as you're looking internally and looking at yourself, you want to look at the components of your business outside of yourself that lead to how you operate, and make sure you've got the right supply chain in place, and those folks are not going to be troubled in a way that's going to impact your business, and as well as your customers, right? Are they in financial trouble? One of the things, if you read any literature on what happens in times of economic distress, and this you don't think about this, but it's actually pretty it's not a surprise at all, which is that in times like we're facing today, the incidence of fraud increases dramatically because you have a lot of borrowers out there, right, who need to keep their trade terms or their credit terms open. And so what do they start to do? They start to fudge their books a little bit to make themselves look better than they actually are. And so you have to be vigilant. You have to look at your customers. You have to look at your vendors. You have to look at the information that's provided. You have to keep your ear to the ground, because the sooner you know that you've got a problem, the better, or the sooner you can react to it, and maybe the better your options are for adjusting for yourself and mitigating against possible damages. Jeffrey?
Yeah, I think the other part of that, in addition to sort of trouble with customers, you may also have some vendors, some suppliers that you're not sure how they're gonna make out as things shake out in a particular industry. So there are some tools that are available to help you, other than obviously taking a look at the contract itself, whether there might be a provision for an ability to terminate or declare some sort of default and head toward a termination, certainly the easiest way. But then there are also rights available for those of you who are participating that may have gone to law school or otherwise familiar with the Uniform Commercial Code, the UCC. There are some remedies that are available under the UCC when you're dealing with a counterparty that you're not sure is going to continue to have the ability to perform. So what you can do, be it customer, be it suppliers, what you can do is go back and sort of make a demand, state why it is you feel that that party is not going to be able to perform, and then you can, with the customer, start to shorten the payment terms. And ultimately, you request information. It's called a request for adequate assurance. And then with that, if you aren't provided with sufficient information and you're acting, obviously the standard under the Uniform Commercial Code is to be commercially reasonable. Is if you're acting commercially reasonable, you can in fact ultimately terminate that agreement. That is a great tool to use when you're dealing with a party that you think is heading toward a bankruptcy. If you've got a customer, a large customer that you think is heading toward a bankruptcy, and you want to reduce your risk, the idea is heading towards imposing shortened credit terms, so your exposure is reduced significantly, and also ultimately the ability to cancel that agreement. So there are a number of tools that are available there to help you. Mark, you want to talk a little bit about sort of the scenario where some key parties ultimately file for bankruptcy?
Yeah, we're going to talk about bankruptcy in a little bit, but in terms of, what happens if one of your customers or one of your suppliers file for bankruptcy? You obviously have to give that some thought and consideration in terms of how it's going to impact on your business, right? What does the filing mean to your business? How is your claim against that party going to be treated in the bankruptcy? When is it likely to be paid? If you have a contract with that party, what does that mean? Is that contract going to be honored by the debtor going forward? What is the debtor going to do? Is it going to reorganize? Is it liquidating? All of these things you're going to need to look at. One of the things you're going to have to consider and think about is preference exposure. For those folks on the webinar who aren't familiar or don't have a lot of experience in bankruptcy, when a company files for bankruptcy, there's actually an ability of that debtor, of that company, to reach back 90 days and to recover payments it made on legitimate debts, assuming the elements of what's called a preference claim are satisfied. And so a lot of times you have to think about, did you receive preference payments? What's the likelihood you may have to give those preference payments back, and when? And obviously that's got to factor into your long-term planning as we go forward. One of the things that we're seeing in some of the bankruptcy cases is, in light of the pandemic, folks are trying to get creative and do things that we've never seen done before. And I'll give you a simple example of that. Under the Bankruptcy Code, once a company files for bankruptcy, and let's take a landlord-tenant situation, even though that tenant who files for bankruptcy may be in default of that lease and owe the landlord money,
Right.
Once they file, they don't necessarily have to pay that amount right away. But going forward, from the bankruptcy forward, the Bankruptcy Code provides that the debtor is supposed to pay those obligations timely. And what we've seen in a bunch of cases, larger retail cases like Modell's Sporting Goods, like Pier 1, we've seen debtors go to judges and say, look, I know the Bankruptcy Code says I have to pay that, but in light of the pandemic, we've got serious cash flow issues, and many of our stores aren't even open. We don't have the ability to service our landlords, and so allow us not to pay it or allow us to defer payment of that rent. And I guess it depends on what side of the aisle you're on here in terms of how you want to argue, but judges have been persuaded that they have the power to allow a debtor to defer some of those rent payments. And so again, if you're dealing with a customer, a tenant, whatever, who files for bankruptcy, you have to watch carefully what they're going to do in the bankruptcy case, because they may try to get creative in light of these unprecedented times to ask the judge to allow them some relief that normally, under normal circumstances, we wouldn't see. Jeffrey?
Yeah, and so Modell's is, as you mentioned, is the perfect storm. So Modell's filed bankruptcy with a view towards liquidating. It was going out of business. It was conducting GOB, going out of business sales across all of its locations. And when the pandemic hit and retail was virtually shut down across the country, here you had Models with no income, no ability to liquidate that inventory. You had lenders that had liens on inventory that it was hoping to be repaid from, sitting in these stores that no one could access. You had third parties that were responsible for conducting the GOB sales that were supposed to be paying their employees, sort of their employees conducting the liquidations. So it was about the perfect storm as it could be. And what they did with Models is they sort of even took it a little bit further. Not only did they say, hey, we can't pay our rent, give us time, we'll pay it later. But they sort of said, we want to just freeze the case. We want to freeze our bankruptcy, just sort of sit down quietly and wait for things to turn around, and then we'll resume. That's pretty unprecedented. It did happen, and sort of the Models rent deferral set off a wave across just about every other retail case that's filed. I think a lot of landlord clients that we have in particular, we've tried to spend some time with our real estate colleagues at the firm educating them about this possibility. That's changing obviously now as retail is reopening across the country, but even you have to look carefully because even that reopening is often at limited stages of sort of people in a store or operating hours or things like that. So it's still not really, the storm is not over yet on that front. So that's something also to be sensitive to. I think one of the other things for a business that's in trouble, particularly when you're facing financial distress right now, when you're not sure of what the future may hold, is whether you should seek some sort of liquidity infusion to help the business go forward. And that is obviously a very difficult decision, oftentimes an emotional decision, because you're really trying to decide, what you really have to try to admit to yourself is, do I think this business can make it or not? What's the likelihood? And what should I do if it's not, or if I think it can, but I just need some additional capital to help me bridge that period of time? How can I do that? So obviously the most logical place to go to in that scenario is your existing lender with a very strong business plan and some cash flows to show how you're going to get past the current environment and how in a period of time, whether it be a couple of years, a year, whatever it may be, that you'll be past that risk and that it makes sense for the lender to lend a little more money because ultimately that a little more money, whatever that may be, obviously, it's all relevant to the size of the credit facility, but with that, the lender might actually better position itself. In other words, by putting that money in, hey, lender, you have a better chance of actually recovering in full on your loan, versus if you don't, and you don't help me, then it's just going to become a very difficult scenario, and you're only going to recover, X percent of what you're owed, and that doesn't help anyone. That's often met with, well, okay, then you're going to have to, owner, have some skin in the game. I want you to put up some collateral. I want to, as we talked about a little bit ago, enhance a guarantee, whatever it may be. And that's a decision that's really on a case-by-case basis. You have to do a very, very honest assessment of whether that makes sense or not. The other scenario is a lender might say to you, or another party may say to you, hey, owner, I want you to put some money in, but I want you to put it in the form of equity. I want you to make a capital infusion into the company. And that's often a very difficult decision as well, because if you're putting money into the company, whether you decide to put that in as debt or equity certainly has implications. Equity, you're last in line in terms of recovery should things go south and you end up in a liquidation scenario. In a debt situation, depending on if perhaps you're able to pick up some junior liens behind a lender, you still might be able to recover. But there are risks with that because depending on where things head, whether it could be in a bankruptcy environment and in some scenarios outside of a bankruptcy environment, just because you decided you've made a loan to the company, a third party may seek to recharacterize that loan. They may sort of say, come on, that's not really a loan. That's really an equity infusion. This is a closely held business. The truth is you were putting money in to keep the company alive. So that is a risk, and the best way to try to deal with that risk is if you are in a situation where you're going to try to make a loan into a company like that, is to really make sure that it is well documented, that it has all the indicia of debt, and that you sort of structure it in a manner that best positions you for a fight kind of down the road if that happens. Mark, I guess one of the other things that we've been dealing with more and more recently are sort of what people refer to as asset protection strategies. Do you want to explain that a little bit?
Sure, and you know, I see it's 11:50, so we'll pick up the pace here a little bit and cover some of these remaining topics pretty quickly. But one of the things we're encouraging our clients to do right now is really look at their businesses and determine whether there are asset protection strategies that ought to be considered. And what that really means is, you know, well, how is your business structured today? And is there a better structure, multiple companies, you know, whatever it may be, that you can isolate key assets and protect them from creditors in a situation down the road? Another thing that you really need to look at is if you have separate businesses, and obviously in boom times, keeping in place the separate or the corporate formalities and actually treating separate businesses separately, you know, if folks have gotten a little lax in that, you know, those kind of facts matter if in fact you get into a stress scenario, because creditors will start to look at the separate businesses and try to say, well, all of those assets should be available to satisfy debts of creditors. So, you know, are you following corporate formalities? If you're not doing it, you probably should be doing it, or setting it, you know, making sure your business is and doing it in a way where you can, you know, the reason you establish separate businesses is for that type of protection. You want to make sure the way you're operating those businesses is consistent with that, so those protections can remain.
Okay, yeah, and I guess one other quick thing, just as we were talking about sort of if your company is in distress or other things, you know, the other thing is this is also an opportunistic time. So if you're in a situation where perhaps you have a competitor who might themselves be in distress, or some supplier that you would love to have a part of your business that may be in distress, this could be a great time to acquire troubled assets from a company. You can do that in a couple of different ways. What often happens is that it's done through bankruptcy. You have the ability, you approach your competitor and say, hey, I would love to buy your assets. I don't want to assume your liabilities. I want to buy your assets. I'm going to do that through a bankruptcy sale process. You often hear of what they're called 363 sales, which refers to a section of the Bankruptcy Code, Section 363. And just in very short description, what that process involves is you negotiate an asset purchase agreement just like you normally would, and then the seller would go into bankruptcy and seek court approval of your asset purchase agreement. There will likely be sort of a competitive bidding process related to that. You are able to negotiate for yourself some protections, some overbid protections and expense reimbursements if you're not successful. But that process particularly is beneficial to a buyer, because what happens is if the bankruptcy court blesses the sale, it issues what is often a very lengthy order, the crux of which is you've taken those assets free and clear of all liens, claims, and encumbrances, which means that the assets are yours, the liabilities stay behind with the debtor, and you can take those assets and move on. So going back to what we talked about at the beginning, in the Hahnemann and St. Christopher's bankruptcy, we were successful in selling St. Christopher's Hospital for Children to a buyer who bought those assets out of the bankruptcy and is continuing to operate the hospital now, but free and clear of the liabilities that were encumbering it previously. Mark, you want to talk about fiduciary duties, sort of the shift in fiduciary duties a little bit?
Sure. One of the things that we've talked to clients about, and we'd encourage you to have the same discussion or to think about, is that, you know, the fiduciary duties that a board, officers and directors have to an enterprise shifts a little bit in a financial distress situation where the company could be insolvent or in the zone of insolvency. And the fiduciary duty always runs to the enterprise, the business itself. But if you're insolvent or in the zone of insolvency, your considerations may have to take into account the impact on unsecured creditors. And a simple example of that would be if, you know, you've got a company in financial distress, you're in a situation where you've missed some covenants with your lender, and now you're going to enter into a forbearance agreement. And the cost of that forbearance agreement from the lender is they want some additional collateral. In a situation where you're not insolvent or in the zone of insolvency, you know, the board would probably quickly sign off on that. But if you're in the zone of insolvency or insolvent, you know, you have to pause, you have to give some thought to what does it really mean to pledge that additional collateral, and what's the impact on the enterprise, and what's the impact on unsecured creditors. I'm not saying you don't do it or you can't do it. You remember, you're allowed to take risks. What you're not allowed to do is take unreasonable risks. And when you're assessing the reasonableness of the risk you're taking, you know, when you're in the zone of insolvency or you're insolvent, you know, that how you analyze that risk may change. And it's something you have to keep in mind, and your board, your officers, your directors have to take that into consideration. One thing you always want to think about if you're dealing with a company in a financial distress situation is, you know, if that company winds up in a bankruptcy. Remember, a bankruptcy is a public, it's an open process. And there may be litigation that comes to that. So you always have to consider, you know, emails, internal traffic, anything you put in writing, you know, could that be discovered later? Is that going to come out later? So you want to make sure you choose your words very carefully, and be careful what you talk about in writing internally when you're dealing with difficult issues and financial distress.
So obviously we are getting close to the end, and we have another question from a viewer. Any possible litigation opportunities in a situation where a bank tells a business that they don't believe that they're going to survive the pandemic, and that as a result they're going to move that account to an asset resolution stage? Any thoughts on that?
Well, I'll start, Mark, and then certainly you should weigh in. You know, I think you sort of have to look at the relationship. A lot of times people are very keen on the concept of what's referred to as sort of lender liability claims, where a lender is acting perhaps unreasonable or being seen as making business decisions for the company, and then it's not able to do that. And I would say that that is a very, very difficult threshold to get past. And I think that even in a situation, you know, you have a contract with a lender has various rights in terms of sort of default scenarios and other discretion. I think the answer there is that that's going to be very hard to fight back, you know, from a litigation perspective. It doesn't mean that you wouldn't take that strategy to begin with to try to come to perhaps a more middle ground of forbearance and a period of time. You know, the one thing when you're facing a lender who is really focusing on default is to try to get to a forbearance stage, so you can set the ground, set the lay of the land for everyone as to what's expected going forward. And certainly threatening that litigation as a part of it is a tool that you can use. Mark, other thoughts that you have?
Well, look, I mean, I'll just echo a couple of things that you say. You know, look, remember, your relationship with your lender is a contractual one, and so their rights are set forth in the contract. And, you know, whether they act consistent with that contract or not, that determines whether you've got a viable claim against your lender. Look, I think lender liability claims are very difficult. You know, once there's a default, if they properly exercise their remedy, you know, they don't have an obligation to continue to lend, right? That's what the contract says, and that's what you have. What I will say is this. You know, so maybe there's not a lender liability claim, or maybe a lender liability claim would be very difficult. But if you are in a situation in litigation with your lender, or you're in a bankruptcy case and you're fighting with your lender, you know, the thing to remember is that judges are people. You know, if the pandemic is really what's caused the issue with a business, and there's really an opportunity for this business to turn itself around, you know, judges are people. They'll assess that situation, and I think judges generally, on an equitable basis, will try to help borrowers if they see there's an opportunity there to do that. Again, they can't rewrite the contract, but if you need a little more time, if you need the judge to help you here or there on an issue to put yourself in a better position, hopefully to reinstate the credit or come up with a way to sell the property or whatever it could be, you know, you can use your charm. And you can use the situation, hopefully, to get the judge on your side.
Right. So it's 11:59. I'm going to try in 30 seconds to just explore what options are available if a company is in financial distress and really thinks it has no path forward. And that is either through a bankruptcy, which everybody has heard about. There's a Chapter 7, which is a liquidation. Third party steps in, liquidates assets, distributes proceeds. Another is a Chapter 11, which is a reorganization process. You can also, as I mentioned, sell assets in that bankruptcy, which sort of makes the 11 a liquidation. There are other out-of-court alternatives. There's what's referred to as an Article 9 sale, where you surrender collateral to a lender, to a secured creditor, in exchange for forgiveness of debt. There is what's referred to as an assignment for the benefit of creditors, which are either governed in particular states. It's a state law remedy, a creature, I guess, or either by statute or common law. And the idea is you assign your assets to an independent third party, and that third party is responsible for the sort of the sale of the assets and liquidation of proceeds. And there are also both state and federal level receiverships. These options, the out-of-court options, are less expensive than a Chapter 11, but there's a lot less certainty and you don't get as much protection from your creditors in that scenario. So, you know, bankruptcy itself is expensive, but certainly in the right circumstances has significant benefits. Mark, do you want to? I know Mark and I talked earlier today about we weren't sure how we'd get through, but you know, make this go for an hour, and I think we've missed a lot of our material. So, Mark, you want to try to wrap us up?
Sure. I'll just make one final comment related to bankruptcy and just really touch on an issue. Folks on the webinar may know that this year there's a new subchapter 5 section of the Bankruptcy Code. It's called the Small Business Reorganization Act. And it's designed to be faster, it's designed to be less expensive, and there are some things about it that are more beneficial to small, quote unquote, small businesses. The original debt limit, in other words, to qualify as a small business debtor, originally you had to have debts of only approximately 2.7 million. With the CARES Act, at least for the next year, that debt limit has been raised to $7.5 million. So that's an option that I think a lot of folks in trouble are going to be able to take advantage of. Again, you know, rather than reorganizing a year or more, the section is designed to get you out of bankruptcy in a few months, 2 or 3 months. And there's some benefits to small businesses that wouldn't be available in a larger Chapter 11. So I see Monique. That suggests to me I'm getting the hook. So I just want to say thanks, everybody, for paying attention. And again, Jeffrey and I are available offline to answer any questions that anybody has.
Yeah,
Yes.
Thank you very much for participating, Monique.
Thank you. Yes, that concludes today's webinar. If we didn't get to your questions and it wasn't submitted anonymously, like I said, we'll send you a follow-up email as soon as possible after this presentation. Our second and final CLE code is 082463. Again, it is 082463. Remember to keep an eye out for the thank you email that you're going to be receiving. It'll have links to our presentation and some other materials, and complete the CLE survey if you're looking for that credit. And finally, if you haven't already done so, please be sure to register for the next webinar in our series. It's called Privacy and Cybersecurity, Risks While Working Remotely. That is scheduled for next Wednesday, July 1st at 1 o'clock p.m. Thank you again, everyone, for joining us. Be safe.
Thank you.
Thank you.